Well, hello and welcome to Newscentre. I'm Ashmit Kumar. Now, top lawyers Harish Salve and Mukul Rohatgi have urged the Supreme Court to curtail the powers of the Enforcement Directorate. They said, and I quote here, "No one is safe in the country if the ED is not reined in." End of quote. Now, the two lawyers were arguing against the arrest of their client, Basant and Pankaj Bansal, the promoters of Gurugram-based realty group M3M Developers. The lawyers also argued that the ED arrested the directors when they had been cooperating. Further, according to the ED's data, under the Prevention of Money Laundering Act, only 24 cases have seen conviction till 31st of January. The number of accused convicted under the money laundering law stands at just 45. Concerns over the probing agency's arrest powers are not new. In April this year, 14 opposition parties had filed a petition in Supreme Court against the arrests made by the ED as well as the CBI of opposition leaders. However, the Supreme Court dismissed the petition. And joining us now to discuss all of this and a lot more, I'm now joined by Mr. Dushyant Dave, a senior advocate of the Apex Court. Mr. Dave, thank you so much for joining us. I'll just recount those words once again from Harish Salve. Drastic powers given to the ED. If not reined in, no one will be safe in the country. Your thoughts on that? Do you agree with that?
I fully agree with that. I think ED, originally trained its guns on politicians. Now it is training its guns on business community. And, it is really sad the way these powers are being exercised, thanks only, of course, to the Supreme Court, which, gave those powers to the Enforcement Directorate. So the powers are being used more often than not abused. And it's not good for citizens that they should be subjected to this kind of draconian powers and, this kind of a very, I would say, harsh treatment that they receive both at the hands of the ED officials and at the hands of the judiciary to a great extent, I must say.
Mr. Dave, let me get your thoughts. You spoke of the Apex Court. The Supreme Court was seized of the matter. There was a whole batch of applications that the Supreme Court was hearing. But in July of last year, the Supreme Court made a decision that everything is kosher with the PMLA. There is no need for intervention and that the ED's powers are justified. You think that that is a lost opportunity from your perspective for the Apex Court?
See, there is no doubt about the fact that the judgment of the Supreme Court in Vijay Chaudhary, which Justice Khanwilkar authored, that is one of the, I would say, darkest chapters in the history of the Supreme Court, because that judgment has virtually turned the law upside down on every principle. The basic principles of criminal jurisprudence, the fundamental principles are twofold. One, presumed innocent, and two, burden of proof. Now, every person who's charged with a criminal offense is presumed to be innocent till he's proved guilty. One. Two, the burden of proof is always on the prosecution or, the authority which is leveling the charge against it. I think, yes, Justice Khanwilkar has turned that upside down and said that, no, you are presumed to be guilty if, you have been proceeded against, one, and two, that you have to prove yourself that you are innocent. So, besides the fact that the Supreme Court, Justice Khanwilkar's judgment said that it is not necessary to give even a copy of the what is known as the ECIR, which is equivalent to a first information report to the person charged. It is good enough if he has indicated the grounds. The judge before whom he is produced will satisfy himself. Now, this takes away the complete right of citizen to defend himself or herself, which is unheard of. And then coupled with that, they say that summons by ED is not an arrest. ED is not a police authority. Therefore, the statements made before the ED are admissible in court. And any kind of a criminal case can be brought within the jurisdiction of the PMLA Act. All these Supreme Court said in this judgment, which is truly, to my mind, I think I would characterize it as one of the worst judgments in the history of Supreme Court since independence.
You've pointed out plenty of lacuna with that judgment, but how telling is it that in less than 30 days of that judgment, the Apex Court decided to hit the pause button and said that, look, wait a second here, there's perhaps room for revisiting this judgment. And there are two aspects that, in fact, it was said in open court as a part of an observation that need to be revisited. Number one, whether or not the ECIR should be supplied to the accused, and number two, whether or not the burden of proof should be on the accused. How telling are these observations coming from the Apex Court less than a month after the judgment?
They are, and I have no doubt that these observations were correctly made. I would say that it's not just these two issues. I think there are many issues on which this PMLA Act. You must understand one thing. It is conceived as part of international conventions to which India is a party, and these conventions were essentially to fight international drug traffic, international corruption cases, and the monies which are taken by the corrupt politicians from across the world into tax havens, and to fight terrorism and financing of terrorism. It was never intended for ordinary criminal cases. So today the act has a schedule in which all kinds of offenses, including under Copyright Act, are brought within the purview of the PMLA Act. The simple cases, including under cheating under Section 420 of the IPC, for example, is brought under that. So as a result of that, I know of a case in which a shareholder filed a case against the managing director of a company saying that, oh, you had cheated 15 years ago. And in that particular case, the Reserve Bank had found that there was no cheating, there was impropriety. Impropriety was corrected. Reserve Bank was satisfied. 15 years later, some shareholder files a case, and within a week thereafter, the ED swoops down and attaches assets worth over 1,000 crores. Now, is this the kind of power that should be exercised by the... Today, ED is completely unchecked by the executive bosses. So, only check can be judiciary. And judiciary is unable to, keep that check. In every case, people are being, sent to jail, and people are not able to come out. Trials will take 5-10 years. So, and as you rightly said, the rate of conviction is very low. But coupled with that, the number of cases that ED has registered has been, I think there is an increase of 10-fold times in last 5 years over a previous period. So I think there is definitely a gross abuse which is taking place here. It would be high time for government really, because ultimately government also must realize that business community needs to, flourish, needs to do business. And if there is anything which is, I am not for a moment justifying wrongdoing by the business community. If they have evaded taxes, they must be proceeded against. You have income tax law.
Sure.
But to bring every kind of a charge under PMLA, arrest people, and then, keep them in, because Justice Khanwilkar said that, no, you are not even entitled to bail, virtually. So, since the burden shifts on you, ED stands up before the court. Every judge in the country says, yes, now you have been charged, therefore we can't release you on bail. Now, this is really a catch-22 situation. We don't need this kind of a, scary atmosphere, because our entrepreneurs, our business community is extraordinarily, good in working and taking this country forward. We don't want to create an atmosphere where the business community feels pressured unnecessarily, avoidably, and, is unable to grow as it must grow. And without their growth, I think this country can't grow.
Right, Mr. Dave. You were mentioning of the cases that have been registered by the ED. Just to bring up those numbers, in 2014, 209 cases. In 2021, that's 3,985. That's a jump of nearly 2,000% over 7 years. So those were the numbers, Mr. Dave, that you were referring to. But again, to play the devil's advocate here, to recount some of the arguments that the centre has made, the centre's stance consistently has been that, look, these are very sophisticated offences that we're dealing at. It needs dedicated, specific legislation with special powers, and that minus these powers, the entire process, the entire purpose of the PMLA would be defeated. That's the government's position.
Well, I have no doubt government has a perspective. But as I said that, this law was essentially to fight drug money, terrorism money and corruption money. It was not to fight, income tax evasions, or some kind of a black money which somebody in business may have. That's gross abuse, according to me. And look, there is a selective targeting here. You are not seeing anybody who is closely associated with the ruling party, whether as MPs or MLAs or as ministers, or those who are closely connected to the ruling party from the business community being even touched, even investigated. There are business leaders today who have brought billions and billions of dollars into this country through Mauritius route. Everybody knows that. And we know how these monies are coming in. But yet no investigations are taking place against such people. So my fear is this, I am not for a moment justifying, anybody's wrongdoing. They must be proceeded. You have the ordinary law available to you. The income tax law has sufficient provisions. You have, GST Act under which you have sufficient provisions.
Sure.
But you cannot use this kind of a draconian law to, target people. That, according to me, is wholly unacceptable. We are a very civilized society. We are a democracy, which is a liberal democracy, a vibrant democracy, as Prime Minister time and again tells us. In such a democracy, abuse of this power or even use of this power, to my mind, is anathema to constitution and constitutional protection.
One criticism, Mr. Dave, of the Supreme Court's PMLA judgment has been that there was no intervention despite there being issues of liberty. For instance, the grounds of bail, the threshold for grant of bail is much higher here. The court has to form a prima facie view that the accused is innocent. Also a question of arrest, no notice to be given ahead of arrest. There is no mandate for recording or sharing of the ECIR, which raises the question whether or not the accused person will be able to defend himself or herself before a court of law. So these are questions of liberty which have been raised. How important is this now for the apex court to consider the entire debate around PMLA from the perspective of life and liberty?
I don't think there is a very great debate required. That judgment has to be recalled. That judgment cannot be allowed to stand even for a day. It is really a sad commentary on the part of the Supreme Court that 3 judges of the Supreme Court sat in that bench and delivered that judgment, although it is authored by Justice Khanwilkar. I feel that it would be high time for the current Chief Justice of India, Justice Chandrachud, to ensure that somehow this matter is taken up and it is reviewed and recalled as soon as possible before other people are being targeted. Because for citizens, even a day's liberty is crucial, is very important. You are taking away liberty of large number of people, from the politics to businesses to professions. It's not required. You don't need it. What have you achieved? Have you been able to stop black marketing? You haven't. Have you been able to stop black money? No, you haven't. That's why you are now demonetizing 2,000 rupee notes. So all these powers are only for the purpose of abuse and nothing else. Nobody is checking, nobody. There are nothing coming out about this. There is no supervision, there is no guidance. And I think judiciary, which is supposed to be a protector, has failed to protect. So I think judgment, as Chief Justice Chandrachud stated the other day, that judgment on statutory, bail, that kind of a stay he should grant so far as this judgment is concerned. He must immediately state. If maybe government will not move naturally, because government is happy with this kind of draconian powers, but somebody must mention to him and he must state. If he can state at the instance of the government something which is in favor of the government, he must stay at the instance of citizens to protect their liberties, even if it is a single individual's liberty for a single day. And here, hundreds and thousands of people are suffering today in the country. There are all kinds of raids taking place. There is a fear atmosphere which is developed in the country. And I know, I can tell you one thing, that in the business community, people are really very seriously worried about it. Very seriously, which is not a good thing, because business community is as important in our society as any other section of societies.
Right, Mr. Dave. Thank you so much for your time and perspective. Strong words, as always. A message for the chief, for the bench to consider this matter. And just for the perspective for our viewers, the review application is still pending before the top court, and there is room for some action there at the top court. Mr. Dave, thank you so much once again for sharing your time and perspective with us. But with that, it's time now to slip into a very short break. But coming up, the much-anticipated Digital Data Protection Bill has been cleared by the Cabinet and is likely to be tabled in the monsoon session of the Parliament. We assess the possible impact of the bill when we come back. Welcome back. You're watching Newscentre. Now, the much-anticipated Digital Data Protection Bill has been cleared by the Cabinet, and sources tell us that it is likely to be tabled in the monsoon session of the Parliament. Now, the bill seeks to address issues with regard to data privacy and data security in the country. The initial draft of the bill was put forth in November last year and has gone through several rounds of public consultation. Following the feedback, a second draft was made, which went through ministerial discussions. The draft bill focused on personal data and sought to regulate personal and non-personal data as well. The bill, when passed, will also apply to the processing of data outside of India if it involves offering goods or services or profiling individuals in India. For more on this, we're now joined by Rama Vedashree. She's the former CEO of Data Security Council of India, as well as Aprajita Bharti, co-founder of TQH. Thank you so much for joining us. Ms. Vedashree, let me come to you. You were a part of the initial deliberations way back in 2017. Looking back at that experience and looking now at the latest bill, what are your takeaways in terms of what the industry has to now deal with in terms of compliances? We have easing of data localization norms, easing of norms on sharing of personal data, penalties have been reduced. Are you happy from an industry perspective?
Yeah, first, I think what has been taken to the cabinet, we still don't know, right? Because that will be known only when it's tabled in the parliament, I understand. So we are commenting on the November 2022 version, which I think was lacking in a lot of the details. So we are waiting for what is the final version that is actually tabled in parliament. Definitely, I think some of the provisions that came up in that version were quite music to the ears of the industry members. But still, the lack of details is worrying, because when any industry member, whatever is the company in any sector, looks for some clarity when they go ahead and implement the privacy program to be able to conform and comply with the bill. So I think it was lacking in a lot of details. While it is focusing on digital data, from the privacy supporters or people who want a strong privacy regime in the country, while there is mention of digitized data, how will it pan out actually when even in a fully computerized, digitized environment, there is a lot of paper-based data collection or information collection. So some of these ambiguities hopefully are getting resolved, because various industry bodies and industry members did give submissions to MeitY, and I'm hoping they're all factored in the version that has been taken to the cabinet, and as we hear, it has been approved.
Sure. Ms. Bharti, let's get you in on this conversation. Your first reading, again, the latest framework that we have, of course, is the November 2022 draft. Basis that we're making these informed suggestions. I would like to put to you a comment that came from Justice B.N. Sri Krishna. He was not entirely happy with the structure of the Data Protection Board, saying that it cannot possibly serve as a regulator, given as how it is likely to operate as a captive entity of the government, and therefore not perhaps successfully perform the role of a regulator, of an independent regulator.
Right. So, hi, Ashmit. I agree with Rama here when, she says that we don't know what we are commenting on right now. But I think in the 2022 bill that we had, you're right, there were issues around, and I think Justice B.N. Sri Krishna also did mention that, we don't have a data protection authority or a regulator-like structure that we had in the earlier drafts of the bill. So obviously, we don't have that one arm distance from the rule-making powers that MeitY now has that we had earlier. This is not just problematic from the perspective of having a check and balance when it comes to making rule, the power of making rules, but it's also problematic from the perspective of, for example, what is EU's requirement for, India to be a country where, they let their citizens' data to be there. So I think some of those issues were unresolved when it came to cross-border data flows as well, that I think the industry will be looking at with much interest, because in the last bill, we also had provisions regarding whitelisting countries where Indian data could be stored. But I think the industry really made their opinion known that it should be a blacklisting process, because whitelisting process is likely to be slow. So not just this issue about Data Protection Authority, I think there were many issues that were unresolved. And I think broadly, there was also just I think concern about too many things left to delegated legislation, and too much power to make rules, and no provisions regarding what the rule-making process would look like. So we are hoping that in the next draft that also has been taken into account.
Sure. Ms. Vedashree, let me come back to you in terms of the obligations that have been cast on data fiduciaries. Again, from an industry perspective, do they appear to be onerous? There are some compliances with respect to age gating, where consent is sought to be required from the parents. There are certain compliances which the industry at the consultation stage had red flagged. Your take on that?
Yes, I think at least some of the provisions, like, removing of the criminal liabilities, industry did welcome on that. But the entire responsibility of children data and consent of the guardians, and how do we implement that? I think worldwide that has been a problem of how would a data fiduciary or a controller implement this entire age gating. Particularly in India, we do have this challenge of how do we reach out to those parents and guardians for their consent. I think at the level of implementation, we do foresee challenge as
Sure.
Privacy professionals. But as Aprajita pointed out, I think the lack of details is what would be worrying, because a lot will be left to delegated rule making, which would be the purview of the executive, which in case here is the MeitY or Ministry of Electronics and IT. So we need to wait for a lot of these details. The bill itself does not throw much light, but I do agree implementing a comprehensive compliance program to meet some of these provisions around protecting children data. It is a welcome measure, I think, but how do we go about implementing that would be a challenge. And anything there where there is so much lack of detail and we have to wait for delegated rules to be made, I think that would always be a challenge.
Sure. We're almost out of time. Aprajita, I'll come to you for one final comment, only 30 seconds. One common criticism has been the exceptions and the exemptions granted to the government. That has received some criticism from no less than Justice B.N. Sri Krishna himself. Your quick take on that?
I think, Ashmit, that is something which is very worrying about the bill, and we saw it, for example, with the Govind data breach, right? That was something that was again highlighted when we had the recent data breach, that if the government itself is exempt from some of the obligations of the fiduciaries, then the digital public infrastructure that we are creating and a lot of data that rests with the government is also at risk. And that is something which, again, same as I was just talking about, that do we have advocacy, do we fulfill the advocacy norms of, say, for example, EU, etc., would depend on some of those clauses as well. So that is something that we also need to address. Sure. And just one last thing on implementation, in 2021 version that the Parliamentary Committee had done, there was a 2-year period for implementation of the law. In the last version, there was no specified timeline. So I think it will be interesting to also see when the bill comes in that what is that timeline looking now for the industry to prepare itself.
Indeed, a lot of question marks at this stage, which will begin to get answered once the final version is put out in the public domain. Ms. Vedashree, Ms. Bharti, thank you so much for your time and perspective. But that's all the time that we have for on this edition of Newscentre. More news and updates will continue right here. Keep watching CNBC TV 18.